Supreme Court analyzed following issues in the matter of VINUBHAI Mohanlal Dobaria versus Chief Commissioner of Income Tax. Whether an offence under Section 276cc of the Income Tax Act 1961 could be have said to be committed on the actual date of filing of return of income or on the day immediately after the due date for filing of returns as per Section 139(1) of the Act. What is the meaning of the expression first offense appearing in Clause 8 of the 2014 guidelines? What amounts to voluntary disclosure for the purpose of Clause 8 of 2014 guidelines? Whether the 2014 guidelines are mandatory or directory in nature. Supreme Court held that paragraph 4 of 2014 guidelines specifies that compounding is not a matter of right of the assessee, and the competent authority may allow the compounding application upon being satisfied that the applicant fulfills the eligibility conditions and keeping in mind the conduct of the appellant, nature and magnitude of the offence, and the facts and circumstances of each case. Further, paragraph 7 of the guidelines prescribe the eligibility conditions, and paragraph 8 provides those cases which are generally not to be compounded. Paragraph 9 carves out exceptions and empowers the Minister of Finance to relax the condition laid down in paragraph 8 of 2014 guidelines and allow compounding in a deserving case. A plain reading of 2014 guidelines reveals that while it is mandatory that the eligibility conditions prescribed under paragraph 7 are to be satisfied, the restrictions laid down in paragraph 8 have to be read along with paragraph 4 of the Act, which provides that the exercise of discretion by the competent authority is to be guided by the facts and circumstances of each case, the conduct of the appellant, and the nature and magnitude of the offence. Seen thus, it becomes clear that the restriction laid down in paragraph 8 of the guidelines are, although required to be generally followed, the guidelines do not exclude the possibility that in a peculiar case where the facts and circumstances so require, the competent authority cannot make an exception and allow the compounding application. We have also had the benefit of looking at the guidelines for compounding of offences under Direct Tax Laws 2019 and the guidelines for compounding of offences under Direct Tax Laws 2022 issued by the CBDT. In both the said guidelines, the offence under Section 276cc has been made a Category A offence instead of Category B offence and is compoundable up to 3 occasions. Although this would not have any direct implication on the case at hand, since the same is governed by the 2014 guidelines, yet what this indicates is that there is a clear shift in the policy of the department when it comes to the compounding of offences under Section 276cc in particular, and making the compounding regime more flexible and